And get started. So we've been talking about this whole situation with JSO and William McNeil. There has been back and forth like crazy. If y'all didn't watch the last video we did covering this, make sure you go watch it and read and interact in the comments, because the comments are on both sides. If you're not aware of what I'm talking about, there was a gentleman, William McNeil, was stopped by the police. It was alleged that he didn't have his lights on while it was raining and he didn't have a seatbelt, and he wasn't wearing a seatbelt. Things escalate. Mr. McNeil locks himself inside the car. The police tell him to get out, that he's under arrest for resisting. Officers break the window. He gets open hand punched in the face. They pull him out of the car. He gets punched a couple more times, and then they arrest him. He's bleeding. He chips a tooth. Obviously, now they're filing a lawsuit. The officer in question has been placed on some type of desk duty or administrative leave. And now we're trying to wait to see what the JSO is going to do. So far, the JSO has stood 10 tones down on the fact that there was no criminal action, or there were no criminal actions done by the police officer. We're going to get into that here shortly. Now, they're also saying that William McNeil pled guilty, and now he has an attorney, a new attorney representing him or joining his team, Ben Crump, who has been fighting for him and showing the narrative that this man was not only attacked by the police, but he was falsely stopped and illegally stopped. And he wasn't even in his right mind when he pled guilty to the charges of driving on a suspended license. So fast forward to where we are now. There's been so much back and forth. I told you guys about the video the lead attorney did, an excellent breakdown from JSO policy and talking about Florida law in general. And there's been a lot of back and forth about this topic in the YouTube space, and specifically LawTube. Now we're going to hear someone who leans more onto my opinion or my side when it comes to this whole situation with William McNeil, and that is going to be Nate the Lawyer. Shout out to Nate the Lawyer for this video. Y'all make sure you go check him out, subscribe to the channel. I'll be leaving a link to this video in the description for you, and he's going to tell us why so many people, including the lead attorney, are wrong about this being an illegal traffic stop, and why the officer, even with what we saw, the force that they used, they might be in the right here. All right, let's go ahead and check it out and see what Nate the Lawyer has to say.
Number one, probable cause is not necessary when officers are employing a traffic stop. The standard is reasonable suspicion, and we're going to talk about that.
Probable cause for the stop.
The second thing he mentioned is about it not raining at the time the car was pulled over. That too we're going to have to address, and we're going to address it also a little later when it comes to our boy, the lead attorney. And then lastly, he says that because the officer said there were unknown occupants in the vehicle, that means the officer did not see Mr. McNeil without his seatbelt at the time. So we'll address each one of those in kind. First, let's talk about the aspect of whether it's raining at the time this car was being pulled over. I'm going to say this is probably one of the worst arguments I hear about this particular case.
Hold on, let me say it again. This is one of the worst arguments, and I agreed. I've been saying the same thing. We'll let Nate explain it.
In kind. First, let's talk about the aspect of whether it's raining at the time this car was being pulled over. I'm going to say this is probably one of the worst arguments I hear about this particular case.
The worst.
Lackluster believes that since it's not raining at the time the car was being pulled over, that doesn't mean it wasn't previously raining when the car was driving down the road. Now, It is extremely likely, meaning that during the rain, the officer observed this car driving without its headlights on.
And people were saying, oh, but look, it's the other officers didn't have their headlights on. Oh, it was an illegal stop. Again, I said this, I haven't seen evidence to show that it was not raining when the officer initially stopped him or observed this action and pulled him over. We don't know because we didn't see any video showing that. So again, I agree with Nate here, right on point.
And then when it was able to be pulled over, the rain had stopped.
It wasn't raining. Look at this video. This is fresh rain droplets still hanging onto his vehicle. If somehow it wasn't inclement weather, which means it wasn't raining at all,
exactly,
you wouldn't still see rain droplets on his car.
So lackluster's assumption that because it's not raining right now at the moment the car is stopped means that it wasn't raining when the car was driving down the road is idiotic, just to say the least. It's just idiotic. But you're going to see a lot more people make this argument, but it is a dumb argument. Now, what if the officer said, I pulled you over for speeding? Would the argument be, well, hey, look at the body cam footage. The car is not speeding at that particular time. So that means he wasn't speeding at all. You would automatically come to the conclusion that, hey, he was obviously speeding before when the officer observed him, and now the officer's pulling him over and trying to issue a citation for that observed speeding in the past. This is not.
And this is my thing too. I don't know where people were saying, oh, it's not raining right now. The other officers didn't have their lights on. Well, obviously it's not raining because it's not raining. The officer's saying it was raining. You didn't have your lights on. That's why I'm pulling you over. And even Mr. McNeil himself, he said, it's not raining. It's not inclement weather. The officer said, okay, I'm not arguing with you. I'm just telling you why I'm pulling you over. Come on, people.
Hard people. Now, we're going to have to tackle this issue about it raining and during the rain when we talk about the lead attorney, because he's totally wrong about his analysis on this. But now let's continue with Lackluster, because he also says that because the officer said there were unknown occupants, that automatically means that he didn't observe the driver without a seatbelt.
Hello, Echo Charlie Whiskey on a silver Kia, unknown occupants.
Now, this is easy to debunk also. Why? Because the officer is saying he doesn't know how many occupants are in the vehicle, but he does know that there's a driver, and that driver is not wearing a seatbelt. Why? Because he couldn't see into the back seat, and the windows are tinted. So when trying to relate how many occupants may be in the vehicle, he says unknown occupants. That doesn't mean there's no occupants in the vehicle. That means he just doesn't know how many there are. But he does know one thing. He observed a driver without his seatbelt on. And then lastly, we have to address the issue of whether there is probable cause to make this traffic stop. Now, Lackluster asserts that there is no probable cause to make this traffic stop.
These two facts eliminate all probable cause for the entire stop, which means everything that occurs after this moment was unlawful.
Now, let's say Lackluster is correct in saying that there was no probable cause for the stop. But then he goes and says that means everything that occurred after is unlawful. But you don't need probable cause to make a traffic stop as a law enforcement officer. You need reasonable suspicion. Here is the U.S. Supreme Court saying that. Quote,
again, guys, I said this multiple times on the live streams. We've covered this, and I said it in the videos where we talked about it, and even in the comments. If you're going to exercise your rights, please make sure you understand your rights. Please don't just go out here arguing with police officers and resisting police officers just because you feel like you're allowed to. That's not the case in every situation. Know and understand your rights. Know the difference between probable cause and what Nate's about to talk about here.
Accordingly, we hold, except in those situations in which there is at least articulable and reasonable suspicion that a murder motorist is unlicensed, or that an automobile is not registered, or that either the vehicle or an occupant is otherwise subject to seizure in violation of law, stopping an automobile and detaining the driver in order to check his driver's license and the registration of the automobile are unreasonable under the Fourth Amendment. Now, any legal book you look in, they're going to say for traffic stops, you need reasonable suspicion. The Supreme Court has deemed it. The Florida courts have deemed it. Everywhere you look, reasonable suspicion is necessary for traffic stops, which is a lower standard. The Florida Supreme Court has even ruled this. In this case, State v. Daniels from 1995. Quote, any police officer may at any time, upon reasonable cause to believe that a vehicle is unsafe or not equipped as required by law, or that its equipment is not in proper adjustment or repair, require the driver of the vehicle to stop and submit the vehicle to an inspection and such tests with reference thereto as may be appropriate. Now, Lackluster responded to my criticism and left a couple of comments in the chat. So this is what he said. Quote, while you're correct about the differences between PC and RAS, probable cause and reasonable suspicion, the two infractions cited by Officer Bowers meet the threshold for probable cause when observed. Reasonable suspicion is simply the minimum requirement for a traffic stop. He agrees. The examples you cited work well for the examples you choose, but apply reasonable suspicion to headlights during rain. If it's raining, the driver has no headlights, you don't have to be suspicious on whether they aren't using headlights. It's observable.
Right. So again, if it's observable, then we have to assume that the police officer observed his lights being off while it was raining. And again, there were water droplets on the car. We can reasonably assume that it was raining when the officer stopped him, and then maybe it stopped raining. Who knows?
Then he goes on to cite the two cases that establish reasonable suspicion is the standard that you need to pull over vehicles, not probable cause. I responded by saying the headlight infraction is a civil violation. Reasonable suspicion is the standard. It turned into a criminal infraction when he refused to get out of the car. Lackluster then responded again and said, I'm not sure what your point is. Reasonable suspicion is the minimum standard for a traffic stop. We all agree. Reasonable suspicion and probable cause are both standards in criminal and civil law. Agreed. Witnessing an offense is probable cause, i.e. witnessing no headlights, witnessing no seatbelt. I agree with that too. If an officer witnesses a person commit an infraction or a crime, they don't have to suspect that any infraction or crime was committed. Then after a little bit of talk about the live stream that I had earlier with uncivil law, he says, furthermore, probable cause is required to issue a citation, even for a civil traffic offense. So now let me read my response back to Lackluster. It says, I apologize. I should have clarified my earlier response better. Let me explain more clearly. First, reasonable suspicion alone is sufficient to justify a traffic stop. While you can certainly have probable cause, the court will specifically assess whether the officer had at least reasonable suspicion when initiating the stop. Having probable cause automatically includes reasonable suspicion, so if probable cause is established, then reasonable suspicion is satisfied. Second, you're correct that an officer witnessing a crime firsthand establishes probable cause. However, remember that for a traffic stop, you only need to meet the reasonable suspicion standard. It's similar to the legal burdens of proof. If I'm required to prove something by a preponderance of the evidence, but instead prove it beyond a reasonable doubt, I've exceeded the requirement, but the standard itself does not change. Additionally, probable cause is the minimum standard required for an arrest. Although a higher standard like clear and convincing evidence may exist, courts only evaluate the minimum standard required, in this case, probable cause, was met to justify the government action. Now, when police went in front of a judge, the judge had to determine whether the stop was legit and whether there was probable cause to arrest Mr. McNeil. And when it came to reasonable suspicion, well, the officer said that he saw the driver without his seatbelt. That would be enough to satisfy reasonable suspicion. Then the second is that the officer said he observed the car driving in the rain without his headlights. That too would be enough to satisfy reasonable suspicion. Now, these two observations by the officers were enough to at least stop the vehicle and investigate further. So Lackluster is just incorrect by claiming probable cause is necessary to stop a vehicle. Now, Lackluster is so wrong, even the case that he cites stands for the proposition, but I don't think he's actually read the facts of that case. So let me give you guys the facts of that case. Wren v. the United States.
Wren versus United States. James Brown was driving his car with Michael Wren as a passenger. Both were young African-American men. They were driving in an area known for illegal drug sales. Police officers patrolling the area for drug offenses observed Brown and Wren stop at an intersection for an unusually long time. The officers became suspicious that the men were drug dealers. At that point, however, the officers lacked probable cause or even reasonable suspicion that the men were selling drugs. The officers...
So basically, just because you're sitting in your car and you're hanging out somewhere for a long time, that's not reasonable suspicion. It's not probable cause. If it's not illegal for them, or they're not committing some type of infraction by sitting in their car in an intersection, in this alleyway, wherever, then you can't stop them. But it escalates, right?
Continued to observe the men and eventually saw Brown commit some minor traffic infractions. The officer stopped the car and approached the driver's side. In plain view, an officer could see plastic bags containing what appeared to be crack cocaine in Wren's hands. The officers arrested Wren and Brown and searched the car as an incident to arrest, finding more illegal drugs.
And the court said this stop was okay because it was a traffic stop based on reasonable suspicion. Now, this is where I have to turn into law professor Nate. Let's talk about this probable cause and reasonable suspicion thing. So let's start with the Fourth Amendment to the Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing place to be searched and the persons or things to be seized. That's pretty straightforward. If the government's going to search or seize your property or even you, they have to do it by probable cause. It literally says that right here. And I need you guys to understand, it does not say reasonable suspicion here at all. So all seizures, all searches must be supported by probable cause. So now I know your next question is, are stops like a Terry stop for stop, question, and frisk, or traffic stops that require reasonable suspicion, are they seizures under the Fourth Amendment?
Which is why you do not have to have your car searched. They say, oh, can I search your car? You say, no, you can't search my car. Why? Because I didn't have my seatbelt on? That's not really a good reason for you to search my car. No, you can't search my car. Okay.
The Supreme Court says yes, they are seizures under the Fourth Amendment. Here's what the Supreme Court said in Delaware v. Prowse, 1979. Stopping an automobile and detaining its occupants constitutes a seizure within the meaning of the Fourth and 14th Amendment, even though the purpose of the stop is limited and the resulting detention is quite brief. Now, I know what you're thinking. You're thinking, Nate, so if a stop is a seizure, then the Fourth Amendment says it needs probable cause. It says right there, unreasonable search and seizures shall not be violated, but upon probable cause, right? It's there. But here is what the Supreme Court decided to do. They went with the spirit of the Fourth Amendment. Even though we have words written on this page, we're not going to treat all seizures the same. There are different types of seizures. There are some seizures, like the ones in the Fourth Amendment, that requires probable cause, but we're going to say there are other seizures that require reasonable suspicion, and we're going to just make that up. And they made that up in a case called Terry v. Ohio.
The one dissenting opinion by Justice Douglas. He strongly disagreed with the decision, saying, quote, "We hold today that the police have greater authority to make a, quote, seizure and conduct a, quote, search than a judge has to authorize such action. We have said precisely the opposite over and over again," adding, quote, "To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness, but if it is taken, it should be the deliberate choice of the people through a constitutional amendment." Now,
courts do this all the time, and Supreme Court notoriously does it all the time. Now, you may hear someone say the spirit of the law, but what it's really known as is legislative intent. And
the spirit of the law, we're not going to get into today because Nate does a great job of breaking that down. Shout out to Nate the lawyer. Again, I'll leave a link to the description, or I'll leave a link to this video in the description for y'all and in the comments as well. Let me know what you guys think about this. When it comes to your rights as a citizen when interacting with the police officer, I think it's very important to understand how that relationships look. I say this all the time. The police have a job to do, which is why I respect police officers. I respect what they do. I appreciate what they do, but I'm not going to have certain conversations with the police officer just out of my rights and protecting myself, because they have a job to do. I have a job to protect myself. So you got to know these things. You got to understand that. And you have to be able to see, in this instance, the police officer, if he had a reasonable cause, if he observed something, if he observed the lights being off while it was raining, if he observed he didn't have his seatbelt on, which Mr. McNeil didn't contend to, he didn't say, "Oh, no, I had my seatbelt on." What he said was, "Oh, it's not raining." Well, clearly we can see it's not raining. Was it raining before? Either way, I want to know what y'all think about this in the comments in the chat. They're going to be mad about this one. I'm already getting called a bootlicker. It is what it is.